Right now, I'm just basically studying. I'm making flashcards for tort law for one of my law subjects. So that's what I'm doing. I'm reading it from my laptop and I'm making flashcards to help me memorize the content and understand it. So that's basically what I'm doing. Hopefully you guys can see this writing in the right direction. Hopefully it's not inverted in camera. But yeah. Hello. Thanks for joining. Hopefully you guys are studying as well, because I think it's exam season for everyone. So good luck to everyone if you have exams. Thank you for the like. Thank you very much for the like. So in this post-it notes, I have questions that cover the whole front of this flashcard and this part to use less space instead of writing all the information on one side and then just writing a few questions on the other side. I find that doing it in this way saves more space, saves more paper, and it's easier to access than having plenty flashcards. So the less flashcards, the better. So right now I'm gonna revise this flashcard which I just made. And by the way, it's not actually raining. I'm just playing raining sounds because apparently it's meant to be relaxing. So yeah, I don't know if you guys like the sound of the rain, but it's not raining by the way. Anyways, just gonna do some active recall, which is basically practicing this, seeing what I can remember. I'm not gonna look at the answers, I'm gonna just look at the questions and answer the questions. What are the requirements for negligence to win a negligence case, basically? So first, there must be a duty of care. The duty of care must be breached. The breach must cause some type of damage or loss to the claimant, and the type of damage or loss caused must not be too remote. What does the narrow rule refer to? It refers to the circumstances in which the manufacturer owes a duty to the consumer. One moment, I think the rain sound is finished. Okay, never mind. Alright, let's get back to work. What four things must the claimant establish for product liability? So first, the claimant, first there must be the defendant must be a manufacturer. The claimant must be a consumer. The item that caused the damage or loss must be a product. And lastly, the form in which the product was distributed is such that left the manufacturer with no reasonable time to no reasonable intermediate inspection of the product. So basically it was produced in a form that left the manufacturer no reasonable time for intermediate inspection. I need to check that one. The product reached the consumer in the form in which it left the manufacturer with no reasonable possibility of intermediate examination. Oh my gosh. The product reached the consumer in the form in which it left. I think the mix is too loud. Okay. The product reached the consumer in the form in which it left the manufacturer with no reasonable possibility of intermediate examination. Sounds so confusing. The product reached the consumer in the form in which it left the manufacturer. Okay, I guess the product arrived to the consumer's location in a way that gave the manufacturer no time to do a reasonable intermediate examination of the product. Gave the manufacturer no reasonable possibility to do an examination, an intermediate examination of the product. So it arrived to the consumer's location in a form which gave the manufacturer no reasonable possibility for intermediate examination. All right. What is deemed manufacturer? Manufacturer is someone who has been involved with the making of the product before it reaches the consumer. Can be installing, repairing, or in some cases, rare cases, supplying products. Similar with the case of Andrews and Hopkinson. In this case, there was a defective steering wheel, and it was not really checked or something like that. And it was basically decided that a competent mechanic would have spotted the defect. However, in this case, the defendant didn't spot it. So in this case, I believe the defendant owed the duty of care to the consumer, and the claim no, the defendant had to check this defect because of the car's age and because of the risk of not checking the steering wheel when repairing the car. Hi, I'm doing good. Thanks for asking. Hopefully, you guys are doing good as well. Sorry for the break. But yeah, let's continue with what does it mean. Someone said, "How are you?" I'm doing good. Hopefully, you're doing good. Someone said, "Hi." Hi as well. Hopefully, you're having a great day. Right now, I'm just studying because I haven't studied for a while. Not gonna lie. So, need to do what I've been avoiding for a long time. Because if nothing changes, nothing changes. Anyways, what does this mean for the supplier's duties? What does this mean for the supplier in terms of the duties owed? Well, this means that suppliers may owe a duty of care to the consumer if circumstances exist in which they owe reasonably to inspect or check the products which they are supplying. For example, if the manufacturer asks the supplier to check the products in case, or if the supplier knew of a defect or something dodgy with the product. So that's when they owe a duty of care to the that's when they might owe a duty of care to the consumer. So yeah guys, as you have seen, oh my gosh, what happened? As you have seen, I've literally just learned this whole flashcard just in maybe like 5 minutes. This is going to be very easy to take to the exam or to just study anywhere, whether it's in the gym, in the bus, so it's perfect. Anyways, let's continue going. Hopefully, I'm hoping to finish making revision cards on the whole chapter 11 because I'm studying a whole chapter. The chapter is not very long, it's just 8 pages, but I think it shouldn't take me too long. It's a lot of quite a bunch of reading, but it's not too bad. Maybe I'll just do halfway and go back to bed because at least I did something today. Anyways, let's see what's next. Oh my gosh. Let's be more optimistic actually. Next revision card. I'm gonna put it somewhere where you guys can see it. There. Okay. The next subheading is what is a product? What do you guys think is a product? What is a product? I'll make sure I'm gonna highlight the keyword in yellow. Product is the keyword. So, according to the text, the case of tourism concerns a drink, but the word product covers almost any item that is capable of causing damage. Well, according to the UK law, English law, a product covers, well, for the narrow rule, for this duty of care purposes, a product covers almost any item capable of causing damage. Okay, this is the definition for the purposes of duty of care, for the purposes of the narrow rule, where the manufacturers or suppliers are liable to the consumer. For example, the case of Donahue and Stevenson, the ginger beer case, a very popular case in English law, where a person bought a bottle of ginger beer, or I don't know, bought ginger beer for himself and his friend, I believe, and he drank it and everything. His friend drank it, and while he drank, as he drank the bottle of ginger beer, he found a decomposed snail inside his ginger beer. Imagine that you are drinking a drink and you see remains of a decomposed snail in your drink. Of course, the victim, fell ill and he wanted to claim against the owner of the shop. However, he couldn't claim against the owner of the shop because the only people who can claim against the owner of the shop are those who are parties to the contract. And the people who are parties to the contract is whoever pays. So between whoever pays and the shop owner, that's the contract. However, the drinks were bought by the friend. So actually, the one that was ill didn't pay for the drink, so he had no contract. So he was like, who can I, how can I claim for this? So then they decided that he could claim against the manufacturer instead of the shop or the bar that sold it to him. He could claim to the person who actually created it, because he relied on the manufacturer to ensure that it was safe or something like that. I learned this case for the first time during A levels, then uni, but you haven't proper studied it fully. But it's a very nice case. If you're interested in law, you should read the case of W and Stevenson. It's a very popular case for tort law. Someone in the comments says, hey, I am, one moment, gonna check your comment in a second. I can't see it fully because of the way I'm holding my phone, but I'm gonna check it on my laptop. One moment. Hey, I'm a law, but I am common law admission test student. My exam is in December. Oh, so you're also a law student, or you want to study law and you have a law admission test student exam in December. Good luck for your law admission test. Very, very good luck. Hopefully you've been studying. You can do it. You can do it. That's very cool that you're studying law. It's very cool. I like it. Yeah. Good luck with your exam. With your exam in December, you still have around 7 months, so that should be enough for you to prepare. Hopefully you've been preparing for the exam. All right, now let's continue. In addition, as long as I can talk about all right, this duty also extends to items with the product. For example, packaging, containers. Next, who is a consumer? Who is a consumer? I'm guessing the consumer is anyone who consumes the product, or is that very vague? Let's see what the textbook tells us a consumer is. The term includes not only the ultimate user of the product, but also anyone whom the defendant should reasonably have in mind is likely to be injured by the defendant's negligence. So basically, the ultimate user of the product and anyone whom the defendant should reasonably have in mind as likely to be injured by the defendant's negligence, such as neighbors. Okay, so consumer is the ultimate user of the product and also anyone who the defendant anyone who the defendant should reasonably have in mind is likely to be injured by the defendant's negligence. So basically, the neighbor. Okay. Sometimes law is confusing, but I just need to make it make sense to me. Anyways, example. Miss Smith is driving her daughter Pamela and Pamela's friend Sandra to school one day when she breaks approaching a bend. Let me read this again. Mrs. Smith is driving her daughter Pamela and Pamela's friend Sandra to school one day when she brakes approaching a bend in the road. Unfortunately, the brakes fail to function as they are defective, having been negligently manufactured. Mrs. Smith's car mounts the pavement, injuring William, a pedestrian. The car then plows into the wall of the house owned by Jennifer. Miss Smith, Pamela, and Sandra are badly injured. The term consumer will cover all 4 people injured in the accident: Miss Smith, Pamela, Sandra, and William. It will also cover Jennifer, whose house is damaged in the incident. They are all people whom the manufacturer of the brakes ought reasonably to have had in mind as likely to be injured by any failure to take reasonable care on its part. Cars are driven on roads adjacent to buildings and pavements, and cars are driven by people who may well be carrying passengers. Wow, this makes more sense. So basically, a consumer is the ultimate user of the product, which is basically if you buy a car, you as the driver are the consumer. And also, a consumer is anyone who the defendant or defendant is likely to defendant reasonably think is likely to be injured by the defendant's negligence. So basically, the ultimate user and anyone who the defendant thinks is likely to be injured by the negligence, meaning if the manufacturer made the car, the main person who's going to benefit from the car, the driver, well, the manufacturer owes a duty of care to the driver, but not only to the driver, because the manufacturer knows that if a passenger enters the car, they'll likely be injured if the manufacturer didn't build the car properly. So thus they owe the duty of care to the passenger. And also the manufacturer knows that if the car is not fixed or made properly and is allowed on the road, it's very likely that the car will probably hit a pedestrian or someone's house. So I guess the pedestrian and maybe the house that was next to the road will be consumers, according to the narrow rule for these purposes. Okay, it's making sense in my head now. Intermediate exam. Oh my gosh, this one is long. I think I'm gonna continue for 2 more minutes and I'm gonna go home. I mean, no, I'm already home. I'm gonna continue for 2 more minutes and take a break. Intermediate. Well, go to bed actually. Maybe I'll continue for 2 more minutes and then I'll go to bed. Intermediate examination. The gingerbread in Dungeon Stevenson. I wonder if you guys can hear the rain. Let me increase the volume. Okay. Intermediate examination. The gingerbread in Dungeon Stevenson was contained in a sealed, opaque bottle. There was therefore no likelihood of anyone examining the contents before they were consumed. However, if there is a reasonable possibility of intermediate examination, then the manufacturer of the product will not owe duty under the Dunning Stevenson narrow rule. What? Oh, okay. Oh. Okay. Okay. Oh, it makes sense. Oh, the reason why, if there's a reasonable possibility of intermediate examination, that the narrow rule will not really apply is because that means that the shop owner must have a reasonable chance to properly inspect the product, and therefore it will be the shop owner's fault rather than the actual manufacturer. But if there was no reasonable possibility of intermediate examination before the product reached the consumer, it will mean that all the trust and everything is on the manufacturer, because there is no reasonable way in which the, let's say, the shop, the supermarket, can check the product properly before it reaches the consumer, meaning that the fault of anything wrong being in the product will be on the manufacturer. So that explains why there must be no no reasonable possibility of intermediate examination by the manufacturer before the product reaches the consumer. I understand it now. I understand it now. Okay, this does not necessarily mean an injured party will be without a cause of action, as duty may be only set up by the party having the opportunity to examine the product, which is basically the normal duty of care. Yes, I understand it now. I think I need to write it in a way that makes sense. In case when I say understanding now, but imagine in 30 seconds I won't understand it anymore. So let me just quickly write down what I understand in easy words. So I'm gonna write it in simplified words so I won't forget. So basically, if there's no if there's no visible chance for the manufacturer, no, for the retailer to inspect it, then it's not a rule. But if there's a reasonable opportunity for the retailer to inspect it, hey, I'm tripping. I am confused now. There is no reasonable examination. Hey, one moment. You see, I already right now I don't understand it anymore, and I understood it 2 seconds ago. If there's a reasonable possibility of intermediate examination, then the manufacturer. Oh, I get it now. I think my flashcard was a bit deceiving. The product reached the consumer in the form in which it left the manufacturer with no reasonable. Let the manufacturer. Oh, it's not about the manufacturer. It was about it left the possession of the manufacturer. Bro, they needed a comma. They need to put a comma because the lack of punctuation gives a different understanding. Or maybe I'm misunderstanding myself. But I'm guessing it's this opposite way because now I don't understand it. The product reached the consumer in the form in which it left the manufacturer. Hey! The product reached the consumer in the form in which it left the manufacturer. Reached the consumer with no reasonable possibility of examination, of intermediate examination. But then this part is different. There was therefore no likelihood of anyone examining the contents before they were consumed. However, if there is a reasonable possibility of intermediate examination, then the manufacturer of the product will not owe a duty. Okay, you can write the first one. So basically, there must be no likelihood of anyone examining the contents before they were consumed. That's what I basically need. There must be no likelihood of anyone examining the contents before they were consumed. For example, a sealed, opaque bottle, as in Donahue and Stevenson. Okay, let me do my highlights. Approved any item causing damage. The duty extends to items with the product. Hey, items with the product. Okay. Consumer is the ultimate user of the product. and anyone who the defendant should reasonably have in mind is likely to be injured by the negligence. Basically, no likelihood of anyone examining the product before they are consumed. Okay, the case. Alright guys, I'm gonna leave now. Probably continue tomorrow. So see you guys hopefully tomorrow. If I join, maybe I'll join earlier or later. I think it's better if I join earlier so I can stay longer. So thanks for joining. See you guys in the next live.